Thank you, Mr. Speaker. Members, I appreciate the amendment. It really is, what it does is adds an additional affirmative defense to the charge of illegal entry. I believe that we've got sufficient those listed. And also, I want to say, you know, if someone wants to claim this, again, Senate Bill 4 is not attempting to interfere in existing federal law. They can seek asylum. If they meet the criteria for it, they can seek asylum. They can do it from whatever country that they're in. They don't have to be in the United States. They can do it on their phone, on the CBP1 app. All of those things are available to them, or they can come through a legal port of entry, go through the process there in person, whatever they want to do. So we're not trying to minimize that, and we're not trying to say that what's happening is not a serious problem in whatever their country of origin would be, but I am saying it doesn't need to be part of this bill. The other thing is, you know, if you were to adopt...
Members, please take your conversation outside the rail.
If you were to adopt this, it essentially guts the bill. We're not able to do what we're attempting to do, which is secure our border from people coming in illegally, because I think we can all guess what percentage of the population would make this claim when they arrived in the United States. 100%. And so although I appreciate the concern, I appreciate the thought, and I appreciate what is trying to be done here, I can't accept this amendment. So,
Mr. Wu, for what purpose?
Would the gentleman yield for questions?
I will.
Would the gentleman yield for questions?
Representative Spiller, I think you've said before you're an attorney, right?
I am.
Okay, but you're not an immigration attorney.
I'm not what?
You're not an immigration attorney?
Well, I feel like one after I've been going through this the last month or so, but no, I'm not. That's not my typical practice.
Well, that's perfect. So part of maybe your education today is from the USCIS, the federal agency that has purview over immigration, and USCIS webpage specifically in application of the Form I-589, which is the application for asylum, it specifically states you may only file this application if you are physically present in the United States and not a U.S. citizen. Did you know that?
Well, I know that it does, that one provision does say that, but I do know that they, number one, the Arizona versus U.S. case reaffirms in the main opinion, reaffirms that you don't have to be in the United States to claim it. And also we know as a matter of practice that the United States government is not doing that. They're allowing people on their phone, on their app to apply for asylum, and they're in Mexico.
And I understand that's your impression of it, but the requirement to apply inside the United States is not one of the requirements, it is the requirement.
Well, as I stated,
in fact, the USCIS continues, at this time, the option to file an online Form I-589 is only available for certain affirmative asylum applicants. You basically have to be pre-approved to a file outside of the United States. Did you know that?
well, I'm telling you that as a matter of practice, that's not what is going on. And that is also not what is reiterated in the Arizona case. And the other thing is, this bill does not interfere in any respect with anyone wanting to claim asylum. Again, this bill is not anti-immigration, it's anti-illegal immigration. And if someone wants to claim asylum, they have every right to do that. We encourage them to do that. People are doing that every day, but it just needs to be done correctly. And I don't think, moreover, it doesn't need to be an affirmative defense to criminal prosecution for breaking the law.
Now, I understand that that's your feeling on what your interpretation of Arizona case says. But are you saying right now that the USCIS, that their information that they put on their public website for the entire United States public to see, that is incorrect and your interpretation of Arizona is the correct version of the law?
I can read to you in Arizona where it says that you don't have to be in the United States if you'd like me to, but I don't know that you're going to like that answer.
So you're saying that the USCIS Immigration Service has misinterpreted Arizona?
I'm not saying that. I don't
Now-
know. I don't know
now
to
the
what you're
USCIS
referring, so I can't comment on that. I'm just saying I know. Number one, as a matter of fact, under the law, under Arizona, it provides for it and says that they can do that. And as a matter of clear practice, that is happening every single day and has been for a long time.
And the USCIS has said, based on the Arizona ruling, that the vast majority of asylum seekers must be in the United States. Only certain people who have already received affirmative applications are allowed to apply online and outside the United States. Do you understand that?
I don't have any reason as I stand here to dispute what you're saying. I don't know. I don't have that in front of me. But I also know that that's not really relevant to the amendment. The amendment has to do with adding an affirmative defense to this. And what I'm saying, asylum is not actually even in this amendment. I'm telling you, to the extent that this deals with asylum, if that's what we're talking about, or to address the issue that's concerned by the amendment, people can claim asylum. And they have every right to do that.
And I absolutely understand that your perception of your legislation. Now, you've said over and over again that it is not your intent to catch up people who are lawfully here, correct?
It's not my intent to do
It's
what?
not your intent to round up people who are lawfully here.
No, not at all.
Okay? And it's not your intent to go after asylum seekers. It's not your intent to go after people who have a rightful appeals process.
Right. The bill does not address any of those. It doesn't encroach any of those areas. It doesn't violate federal law. We're not usurping the authority from the federal government and Senate Bill 4. That is not at all what Senate Bill 4 is about.
And by your answer, I take it that over and over again, you're saying it is not your intent to bring in people who should not be brought in.
Members, please confine your remarks to the subject before the House.
Go ahead.
The amendment
It is-
by Ms. Garcia is the subject before the House. The amendment by Ms. Garcia is the subject before the House. Please confine your
Absolutely.
remarks to Ms. Garcia's amendment.
Okay.
The intent of the amendment is to correct a shortcoming of the bill itself. Now, while you may say that your bill does not intend to do all this stuff, it is not the desire of it. Your bill is a very widely worded bill. It is very broadly worded, and we're telling you repeatedly, despite your objections, that the way that it is worded so broadly would encompass and would take up people who are here lawfully, people who are here legally, people who are in the asylum process, people who are asking for asylum protection, people who are applying for their appeals, people who are seeking other course of interaction within the federal immigration system that may not comply with exactly what you put in this legislation. Do you understand that?
Well, I understand that's what you're saying. I would say that there may be some misunderstanding about this bill, but that's perpetrated by people that are telling everyone that the bill does something that it doesn't. This bill is very specific. It's not general. It's very specific in its criminal application about the elements of the offense for illegal entry. And that has absolutely nothing to do with people that are in our country and have been here for a long, long time, whether they're citizens or non-citizens. Has nothing to do with that. This bill is very specific about the criminal charge, and I would respectfully disagree with your characterization otherwise.
No, I totally understand. Like, of course, it is your perspective that does not affect this, but you've said at the beginning, you are not an immigration attorney. As you answered questions throughout much of this debate, you said, well, I don't know, I'm not familiar with it, I don't know what kind of visa you're talking about. When people bring up a certain type of visa, you say, well, I don't really know it. You're asking us to take your word in your interpretation of what this law does and how it affects immigration law, that you're asking us to just take your word for it, that nothing will happen to all these other people, although the plain language of the text says that it could.
No, I'm not asking you to take my word on anything. I'm asking you to read the bill. And if you read the bill,
I have read the bill.
It doesn't say anything about rounding people up illegally. Show us your papers, all the stuff that I've heard. It doesn't say that. It never has.
And that is part of the problem, is many of the amendments here are adding in protections for things you say you don't intend to do. That for things that you say you don't intend to include, this amendment provides safety, provides protections to protect against the things that you say you don't want to do. And instead of taking those protections, instead of taking the protections that many of the other amendments are offered, you say, well, it's not my intent, but we're just going to leave it vague. For example, you say your law, that this bill does not conflict, and this amendment will help alleviate issues between asylum seekers and the application of this law. Your law would go after individual people unless they could show where their legality was, where their immigration status is. And people who are applying for asylum have up to a year of being in this country to apply for asylum. And during that time, they would fall within your legislation.
Gentleman's time has expired.
Mr. Speaker,
Mr.
I move
Wu,
to
for what
extend the
purpose?
gentleman's time.
The question occurs on the extension of time. There's an objection. There's a record vote. The clerk read the bell. So Mr. Wu voting aye. Mr. Spiller voting nay. Mr. Kane voting nay. Ms. Niabi Carrada voting aye. Ms. Garcia voting aye. Have all members voted? There being 59 ayes and 83 nays, the motion to extend time is denied. The chair recognizes Ms. Garcia to close on the amendment.
Thank you, Mr. Speaker. Members, we're witnessing an attempt to circumvent federal law. We're witnessing and hearing that individuals on the border are able to use their little app to file for asylum. How privileged is it of us to think that young Fabi, 22 years old, who left Haiti to avoid being murdered, has a cell phone? How privileged are we to believe that every migrant that's fighting for their lives has the ability to communicate through an app? How privileged are we to say that everybody who's illegally entering our country will claim this faux asylum? What we're witnessing is a circumvention, if that's a word, of a federal process. One thing I'd like to share with you, I'm not an attorney. I'm a dental technician and dental hygienist by trade. But what I do know is that app that our migrants over the border are using, number one, is not reliable. Number two, takes months for that app to even get them a place in the line to file for asylum. And I want to ask you, especially those of you who are our border residents, what do you think cartels are doing with these groups of migrants that are waiting and hoping to breathe air and to live their lives in freedom? What do you think is happening to them? Well, I'll tell you. They're being kidnapped. They're being raped. They're being murdered. They are being harmed. Their children are being raped. Their children are being kidnapped and put into sex trafficking. They're being turned into sex slaves, and we're facilitating it. We're facilitating it because we're not allowing them to apply for asylum, because everybody would apply for asylum. That is a right. It is a federal right, and we're denying that right. I ask for you to accept this motion, accept this amendment, because what we can't do is go against the system that is in place. And that system allows for migrants to file for asylum. And as you heard Representative Wu state, that to reach the United States of America is one of the prerequisites in being able to file for asylum. And with that, I ask that you vote yes for this amendment. I move adoption.
The question occurs on the adoption amendment. This is a record vote. The clerk ring the bell. Ms. Garcia voting aye. Mr. Spiller voting nay. Mr. Cook voting nay. Show Ms. Swanson voting nay. Mr. Harrison voting nay. Mr. Vo voting aye. Have all members voted? There being 61 ayes and 83 nays, the amendment fails to adopt. The following amendment, the clerk read the amendment.
Amendment by Ann Johnson of Harris.
The chair recognizes Ms. Johnson of Harris to explain the amendment.
Thank you, Mr. Speaker and members. This amendment deals with those individuals who are in the process of seeking an application for a U visa or a T visa. So let me explain. You just heard the amendment which deals with those who are at risk of being trafficked in a foreign nation and are seeking some form of asylum in the United States. This amendment is very similar to the discussion that we had about a week ago, where we are talking about not deporting and getting rid of our witnesses in serious offenses. A T visa is for trafficking. So T for trafficking, for those that are abused sexually or those that are forced into labor. That's the application for a T visa. A U visa is any violent offense in the United States. So unlike the last amendment, this is not an allegation of a crime that is occurring somewhere else. This is about having the ability to prosecute somebody who is committing a crime in the United States. And so under a U visa, these are the types of crimes that we need this person who was either the victim of the crime or a witness to the crime. The requirements for the U visa is that the crime has occurred or violated our U.S. laws, that this individual has specific, credible, and reliable information, and that this person was, is, or is likely to be part of the certifying agency in the detection, investigation, prosecution, conviction, and sentencing of the qualifying crime. So what kinds of crimes are we talking about prosecuting that we want to keep the person here for purposes of prosecution? Abduction, extortion, female genital mutilation. For some of you, this is a big issue politically about gender mutilation. We are saying that under a U visa, if somebody is the victim of or has information about somebody that is committing genital mutilation, female genital mutilation, that you want to be able to prosecute those people and need them to stay in the country for that purpose. Incest, kidnapping, manslaughter, murder, sexual assault, and trafficking. These are the kinds of offenses that we are asking that you not deport the potential witness or the victim who can testify against the person who is committing these serious offenses in the United States. So the reason that we need this amendment that says a person who is pending an application, because this doesn't happen overnight. It happens in conjunction with local law enforcement, with federal officials, requires oftentimes the offense report from that person who is engaged. And I have gotten to witness this firsthand. It is not something that anybody takes lightly. In fact, in my experience, it is really hard for people to get a U or T visa, and it takes a significant amount of time. It requires, just as mentioned, the credibility that they are a witness who is participating with our law enforcement in prosecuting a local perpetrator. So again, this amendment just clarifies we don't want you to commit violent offenses, sexual trafficking against people who may not be a citizen, because it's a win-win. It's a get out of jail free card if the state of Texas purposely attempts to deport that individual without allowing them to go through the process to participate in lawful prosecution.
Ms. Gomez, for what purpose?
Mr. Speaker, would the gentlelady yield for some
The
questions?
gentlelady yield for questions.
I will.
She yields for questions.
Thank you, Representative Johnson. Thank you for your amendment. Again, I hate to beat a dead horse here, but we've heard an awful lot of discussion from this floor and the bill author, and that the intent of this legislation is not to interfere with and or supersede the current federal immigration law. Is that correct?
That's what we've heard.
And absent your amendment, is it your opinion that that is exactly what state law enforcement officers can do?
Yes, it would not only offend and contradict established federal laws with regard to immigration, but specifically with regard to, if we don't take this amendment, the T visa and the U visa, which is an absolute necessity collaboration between both federal and local entities to be able to engage in prosecution of offenders, of people that are committing crimes in the United States, whether that's Texas, Kansas, Oklahoma, whatever it is. This would offend that T and U process that's a national standard.
So currently right now, it's my understanding that, for example, Border Patrol or ICE agents, DEA agents are all extensively trained in being able to navigate this very sensitive issue of perhaps an outcry of necessitating a U visa or the facts that necessitate a T visa. What training, if any, do you know does this bill provide for any of the law enforcement officers that are now going to be granted this carte blanche authority to stop and detain someone for allegedly being an alien, that will be in parity with the training that our federal agencies have to detect these issues?
I'm not aware of any in the legislation, and it contradicts and offends the entire sweeping movement of public policy that we've had over the last decade with regard to trafficking issues. And it also effectively says that under this bill, this entity and this individual would have the unfettered power to override not only state of Texas interests within other conflicting areas of the penal code, but federal requirements that not only would affect national and federal laws, but think about how this would affect another state. Let's say that somebody raped somebody in Oklahoma and that individual happens to be in Texas, and then Texas says, well, I'm going to deport him. That would again violate, if this is somebody who is a witness to a crime in Oklahoma that is going through the proper federal process of a U visa, then Texas again would be offending not only federal but other states' ability to have their own sovereign immunity to protect against crime.
I completely agree with you. So now moving one step further in this process, in this law that I'm assuming this body's going to pass here today, we understand that federal immigration judges, so law enforcement at the federal level, are trained to detect these fact scenarios. These fact scenarios are then relayed to an immigration judge, and the immigration judge at that point makes the determination on whether or not the facts qualify. Under this bill, absent your amendment, what training or discretion does the magistrate have here at the county level have to comply with this law?
I don't see any. And again, just as you say, it takes changing in this law and putting an unprepared, unqualified entity of individuals in an agency to make a determination that completely offends the already established processes under our federal and local governments to establish U and T visas for the purposes of prosecuting violent offenders who have committed crimes in this state, any other state, or the United States of America.
So again, I want to thank you. I agree that whether or not it's the intent of the legislator in this instance, it most certainly has the effect of allowing magistrate judges to override and completely ignore and contradict the federal due process provisions provided to these victims of crimes and or trafficked individuals.
And let's just clarify what this is going to look like. When you have somebody that, let's say that there is an 18-wheeler truck that is being brought in on a smuggling operation, and women are raped in that truck, right? That would be either potentially trafficking, but at the very least a sexual assault, of which what we would want is, upon finding them and having them evaluated and determining who the perpetrator is, we have all of these protections in our Constitution to allow for the person who is accused to then go to court. Maybe they get a bond, maybe they don't get a bond. They're entitled to discovery. At some point, we got to get to trial. That doesn't happen overnight. That can happen in 90 days, 6 months, 2 years. And the whole goal of the U visa and the T visa is to stabilize the victim and the witnesses so that by the time that perpetrator's case comes to court, we have a live witness to testify. We are talking about human being offenses, violent offenses occurring against an individual. This is not a drug case where you can put a drug in a locker and you're guaranteed that it's going to show up to testify in the state's case. These are all cases that involve a person as the victim, and that's why you need either that person who was the direct victim of the crime or a witness to the murder. It's able to show up. And this just ensures, I mean, this is an amendment that just says somebody is properly going through the application process. And again, they don't take it lightly. You can't just call up and say, hey, I was a victim of a crime. The analysis, in my experience, that the federal government goes through to validate that this person not only is legitimately a victim of crime, but there's that key phrase, they are participating in the prosecution. If you just show up and make an offense report and then you bail and say, I'm not showing up for court, that doesn't do it. This provision of a U visa requires that this is somebody who has participated with law enforcement from the beginning to the end of the process to get the perpetrator. So when we think about that idea of, could somebody just cry foul or cry something happened? No. A U visa or a T visa is somebody that is being validated to continue to participate in the prosecution. So this is not going to be some get out of jail free card. This is a unique provision in the U visa and T visa provision that says they are in for the long haul with local and federal law enforcement to prosecute the bad guys. And if we don't accept...
Sorry. Gentleladies, the time's expired.
Mr.
Ms.
Speaker,
Garcia, for what purpose?
Mr. Speaker, request to extend time.
There's a motion to extend time. There's objection to that motion. This is a record vote. The clerk ring the bell. So Ms. Johnson-Harris voting aye. Ms. Garcia voting aye. Mr. Spiller voting nay. Mr. Cook voting nay. Mr. Chaton voting nay. Ms. Hull voting nay. Have all members voted? There being 60 ayes and 83 nays, the motion to extend time is denied. The chair recognizes Mr. Spiller in opposition to the amendment.
Thank you, Mr. Speaker. Remember, I want to say, first of all, I think this is a very well thought amendment. I appreciate very much what we're trying to do here. My concerns are really twofold. I'll be honest. I mean, my concerns are twofold. Number one is that what we're trying to do is prevent illegal entry into our state through places other than legal ports of entry. This amendment, rather, does not do anything to address that. It's an affirmative defense, a potential affirmative defense that would be added to the offense of illegal entry. So, number one, I don't know that addresses the overall concern of illegal entry. We're talking about what are we doing with people that would apply, that came across illegally, and how do we handle that? And I appreciate that very much. I'm concerned with the idea, first of all, the idea that I'm assuming that they could apply, that they could do this from where they are now. They could come through legally, they could go through that process if they want to do it. I'm also concerned with the language of the amendment itself, because the way I read it, it talks about that the defendant has a pending application. And it doesn't say that they had that pending application at the time of commission of the offense. It says as an affirmative defense that they have a pending application. That could be done once they get here. And my concern is not that we're, in all fairness, not that we're creating, that we're providing a safeguard. My concern is that we're creating a loophole. That is my concern, because the way I read that, they could make that application when they get here, and I'm not saying it's not warranted. I'm not saying that they're not entitled to it. I'm not saying that it couldn't be processed and all that, but I am saying it creates a potential loophole that could be abused in what we're trying to do here with Senate Bill 4, and that is to stop and prevent illegal entry. So I understand, anyway, that's my position.
Mr. Speaker.
Ms. Johnson, for what purpose?
Will the gentleman yield for questions?
Would the gentleman yield for questions?
Sure.
The gentleman yields.
Thank you. And Vice Chair Spiller, I appreciate very much you visiting with me about this earlier, and do want to take each one of these kind of concerns as we talk about the amendment. One, what is the mens rea for the offense on this bill, just to start with as a foundation for your bill? Because I'm not, and I may have read over it and I may have missed it, but I'm trying to clarify, what is the mens rea for the offense for the potential persons being deported?
I think it's a strict liability as far as someone coming in. They don't have to be intentionally. I don't know how you cross a border unintentionally, but intentionally, knowingly, recklessly, or with criminal negligence. It's none of those.
Okay, so if it is strict liability, and we play this out, let's say that somebody is kidnapped on the other side in Juarez, and then they are brought into the United States, and they are continuing to be kidnapped through the United States, then under your mens rea of strict liability, that individual would be in violation of your provision of SB4, correct?
Well, they wouldn't be under attempt to enter, because if they didn't attempt to enter, they were taken here.
They are entered.
Right. You're saying on the first, not attempt to enter, but actually enter.
They crossed the border. They
Right.
crossed the border illegally, and they did it because they were kidnapped or trafficked. And again, you're not asking the question, did somebody intentionally or knowingly or recklessly enter? As you said, this is strict liability. The body came over the border. They're now in violation of SB4.
Right. And I don't necessarily disagree that that is strictly the way that the statute reads. You know, you've prosecuted cases. I don't know what prosecutor would want to take that case and say, hey, we're going to prosecute these folks and either put them in jail or whatever, when they were actually the victim and kidnapped. But
that's
nonetheless,
the point.
Yes.
I wouldn't want to prosecute the person that was bound up and put in the back of the truck and brought over because the perpetrator had the intent of trafficking them. I would want to prosecute the person that bound them up. You know what a guerrilla pimp is? A guerrilla pimp is somebody that takes you by force, throws you in a vehicle, and this stuff happens. I have seen it on cases where we've had undercover officers that they've tried to do it to the officer. It is real. So a guerrilla pimp binds you up, takes you, throws you in the truck, and wants to drive you to Houston with the intent that they're going to sell you on the track. I wouldn't want to prosecute the person that was bound and drugged and dragged, but under your bill, the officer that shows up would have to say, hey, you're not a citizen. You didn't cross at a legal point of entry. You got to go.
Well,
and that's why this amendment would say, no, they are potentially a victim of a U visa, having been kidnapped or sexually assaulted, or even potentially a T visa. But those visas are not automatic. So I'm with you if you want to change the issue of pending and have something about pending and ongoing.
Yeah.
But I can't get that authorization overnight to have that witness remain as a witness against the perpetrator.
Right, and I would agree with you. If someone kidnaps someone, bounds them, any of those things, yes, that's the main perpetrator. Those are the bad guys. Those are the folks that we want to go after. And I would submit to you, no, that's not the subject of my bill, but there are countless other bills that we have in our state pending right now in the Texas Penal Code that would prevent that, and hopefully that we could prosecute that if we could prove it.
No, it won't prevent the deportation of the witness. That's my whole key. This was
Right.
my same key last week. I'm asking you not to deport the witness. I get that there are plenty of offenses to go after the perpetrator, but if I don't have a live witness to show up and testify against that individual, it is an absolute get out of jail free card.
Right. And I've said before, and that, maybe I haven't said it in the last 2 weeks here, but I'll say it today. Certainly, law enforcement has the ability to ascertain how they want to handle a particular situation. We know that there are situations where there are victims, there are children, there are women that if things have happened, and that those people are currently processed and they're turned over to Border Patrol now, and they're processed through the due course of the federal system. Law enforcement still has that ability to do that in each one of those circumstances. This is not taking anything away from that. You're assuming, and I understand, but you're assuming that if someone is bound and kidnapped and brought over here, that they're somehow going to be prosecuted. And I'm telling you, I would give credit to law enforcement and say that, you know, they've got the good judgment to decide who's prosecuted and who's not, and who's arrested and who's not.
So this is why, and I didn't get to ask you about this a couple weeks ago, but they don't have the good judgment. We just passed a bill that says that DAs can't say, I'm not going to prosecute a certain crime. And now you're saying that some police officers can make the determination, I'm going to take this person in and deport him, or I'm not. How do we make that determination? What is in your bill that gives instruction to LaPorte ISDPD versus Federal Task Force on Child Trafficking? What gives them the direction to say, if it's a 14-year-old that was raped in the back of the truck driven over a border, don't apply this law, but if it's a 14-year-old that's jeans were too tight or was wearing a crop top and looked like she was into it, then do you see how I'm showing the absurd nature of claiming that one law enforcement individual over another can make a determination in violation of the plain meaning of your strict liability statute?
Well, and let me back up a second, because I may have misspoke some. And under, yes, that if someone doesn't meet the requirements of intentionally, knowingly, recklessly, or with criminal negligence, but Section 6.02 of the Penal Code provides that if there's no mens rea or nothing prescribed, that you use the standard of recklessness.
Wait, because I don't want to put the wrong thing in the record, because I think this is important. There is mens rea, but then there's still strict liability. So, for example, on trafficking of a child, you don't have to know that they're under the age of 18. It's a strict liability statute. And so here, when you say there's mens rea, there's always mens rea, but the mens rea would be, from my reading of yours, the body went from one point of the border on the other side of the border and didn't go through a legal point of entry.
Right. And
is that accurate or not accurate? Because I do think that's a very important point.
What I'm saying is, I think under the scenario that you've previously described, while I was thinking that it was strict liability, what I'm saying is, upon further reflection, that there would be a certain element of recklessness, and the victim, the person that is kidnapped, that's brought over, that you just gave the example of, would not have acted recklessly. There's nothing that person did, so therefore they would be exempt from prosecution based on your example.
You got to show me where that is before we get lost on this point, because he's about to bang that gavel.
Yeah. It's 6.02C of the Penal Code.
But that's mens rea on the Penal Code. Where does that apply in here?
Gentleman's time's expired.
I would ask for extension of time.
Ms. Johnson asking for extension of time. There's objection to extension of time. This is a record vote. The clerk will ring the bell. Show Ms. Johnson Harris voting aye. Mr. Holland voting nay. Mr. Spiller voting nay. Mr. Cook voting nay. Mr. Smith voting nay. Ms. Hull voting nay. Mr. Patterson voting nay. Have all members voted? There being 60 ayes and 81 nays, the motion to extend time is denied. The chair recognizes Ms. Johnson Harris to close on the amendment.
Members, I'm confused as all get out, and that's part of the problem. I understand when he says there's a mens rea element in the Penal Code, but it's not in this law. It's not in this provision. So when, respectfully, Mr. Spiller says, hey, if that scenario shows up where it's a 14-year-old that was gorilla pimped in Juarez, put in the back of a truck, raped, and driven to Houston to be sold on the track, well, an officer can just make a different determination or not. I don't see that. One, how do you figure that out? Who do you trust, and where are we supposed to be in the law? Like I said, we've just said DAs don't get to make that call and say, I want to prosecute some and I don't want to prosecute others. We look at the plain language, we look at the black and white text, the words that are on the page, and in here, 6.02 is not referenced anywhere in this bill. And it basically says, if your body crosses, and that's part of the challenge, in what way? There's no ability to look at the gray or the victim population that we all know we need a T visa and a U visa for. And instead, the great state of Texas is just going to say, if you're not a citizen and you're a victim of a violent crime, whether it's sexual assault, trafficking, kidnapping, murder, manslaughter, we're going to deport you. This is the most illogical thing for public policy for prosecution and law enforcement. And I can't get my head around why we won't just take the amendment and say, sure, if you're a victim of a crime and you're cooperating with law enforcement to go after the perpetrator that's committed violent offenses in the United States, we would like to get that person off the street and in prisons in the state of Texas and not deport our witness who can make that happen.
Ms.
Speaker,
Gomez, for what purpose?
will the gentlelady yield for some
The
questions?
gentlelady yield for questions.
Yes.
She yields for questions.
Thank you, Representative Johnson. And I know we were trying to get to this earlier with the bill author, but I think what you're referring to is,
Members, please take your conversations outside the rail.
I think what you were referring to is section 51.02A of the bill, which specifically states a person who is an alien, and mind you, that's an undefined term in this section at least, commits an offense if the person enters or attempts to enter this state directly.
Correct.
Under that language, where is the alliteration of intent?
The standard thing you and I would look for in either prosecution or defense, which is if anybody here gets arrested for DWI, it's going to ask, did you intentionally and knowingly operate a motor vehicle while under the influence or loss of normal use or your mental or physical faculties? Intentionally or knowingly. That's not in here. And because that's not in here, it means it's strict liability. It means you entered. It doesn't say you entered sober, you entered voluntarily, you entered involuntarily. And that's the point of the amendment. The amendment catches up those individuals who may have entered and in the course of it, because we talk about it all the time. If there's an 18-wheeler that gets picked up, if there's a bailout, everybody tweets real quick about how you care about the border and human trafficking. And I'm just saying, hey, follow that through. Because now you're going to have to say, I care about it, but by the way, immediately deport those witnesses so we can't prosecute the people who did it. I mean, this is literally absurd.
And
It's an absurd result.
Representative Johnson, I completely agree with you. And I want to just go on a little bit further to the point that you made earlier, which was, in light of the most recent legislation that this body has passed, what discretion does the district attorney have to now make this perhaps compassionate or intelligible option to not prosecute?
And again, it's not just not the DA, it's not the officer on the side of the road. And look, I voted with the majority on that DA bill. I took the vote with you because people, if we say, hey, this is the law, people ought to follow it. I don't think you should have one county versus another county and say, if you drive in here, we don't care about weed. If you drive over there, we don't care about that. If we pass a law that's a criminal violation, everybody should follow it. And that's what keeps driving me crazy when I hear, as a response to, hey, maybe we haven't quite baked this out or figured it out, we're going to trust individual law enforcement officers to make the judgment call on the ground that we can't make in here.
And I guess
if you can't vote for this, what makes you think some officer on the side of the road is going to get the complexities?
I know that at least you and I have squabbled with indictments being overly vague, with laws being unconstitutionally applied. It is my belief, and I hope you agree with me, that absent this clarifying amendment, indictments of this nature with fact patterns of this scenario would be subject to a constitutional as-applied challenge. Would you not agree?
Yes. And not just in those circumstances where you have a case, but we're talking about the population of people that may be deported without due process in violation with the fact that there are federal laws, not just for the federal government, but for the other 49 states that want to convict their perpetrators in their state to keep witnesses here. So it really is, if we pass this without the amendment acknowledging the realities and the existence and the necessity for U visas and T visas. U visas and T visas aren't just a Texas thing. They're not just a federal thing. They are an Oklahoma thing. They're an Alabama thing. They're a Georgia thing. These are provisions of the federal government that protect the prosecution of offenders in 49 other states. So by not accepting this amendment, you're also telling those people, we don't really care about your prosecution system locally because we've got an officer that may or may not make the right call, And we can't even have the debate here to figure out what it is. If we can't get this down on paper now, what makes you think law enforcement and a variety of law enforcement are going to get it on scenes at 2 a.m., 3 a.m., and not screw this up?
Thank you. And Representative Johnson, you've made several good fact pattern suggestions in that several fact pattern representations that perhaps individuals are, and this happens often in our county, trafficked on 18-wheelers. The way I read this section, and I'm just asking if you agree with me or not, it's if a person enters or attempts to enter the state directly from a foreign nation at any location other than a lawful point of entry.
Correct.
Under that reading of the bill, would an individual who is trafficked or who unlawfully crosses at a point of entry, would they be exempt from this law the way it's written?
I'm sorry, would you repeat the last part of the question?
Under this 51.02A, the way this statute is written is it is a crime to attempt to enter the state directly from a foreign nation at any location other than a lawful point of entry.
Yeah, so just let's take this example of a U visa, abduction. If somebody is abducted and they are brought across the border at not a legal point of entry, then potentially they are both the victim and the offender of this law. And so in that circumstance, you need to figure out which do you want to apply. So that's what leads to an absurd result in the law. When you have an individual under a fact pattern where on one hand we could say they are the victim of a crime of which we want to prosecute, but then on the other hand say the exact same conduct results in their deportation. So extortion, false imprisonment, kidnapping, hostage. I mean, literally, the U visa spells out all of these scenarios. Somebody who's being tortured, somebody who is a slave trade stalking, peonage, somebody that is indentured servitude to somebody. Any of these categories, you can envision any of these people that are brought over. I mean, we're talking about domestic labor, we're talking about sexual labor, or we're talking about just straight up what we call serious offenses under a U visa. And the fact pattern that leads to the necessity of the U visa would in effect also lead to the potential violation of SB4. And that's what makes it absurd.
Absent your clarifying amendment here, which I believe is absolutely necessary for due process, what jury charge, if any, does this bill provide to ensure
you
that...
You never get there. So, I mean, you never even get to the idea of having a jury charge because you never get to the due process of getting to a jury. You get to this original determination where a magistrate or somebody may kick you, and when they kick you and get deported, I don't see any mechanism in here of which you can say, hey, I want a jury trial for the jury to determine that if the 14-year-old little girl that was gorilla pimped, gang raped, and brought over in the back of an 18-wheeler from Juarez into El Paso gets an opportunity to have El Paso prosecutors prosecute the offender, right? I don't see in here where there is an appropriate mechanism other than the amendment, which again would say somebody is pending a proper application to do this. That's got to give validation that they're actually going through the process and continuing to cooperate with law enforcement. Other than that, you get the wrong officer, they kick the witness out. And look, organized crime is organized crime. I mean, there's a reason we have an in public integrity unit, because sometimes they're bad police officers. So if you just say, hey, we'll get the right cop, what if you get the wrong cop? What if you get the wrong cop that's on the take for the cartel and says, no, we're deporting this one back. That's too good of a case. That's too good of a witness. I'm going to ship that one out. None of these safeguards are in here for either what's happening overseas or, more importantly, this is dealing with crimes that occur in the United States. Whether they start somewhere else and come over, it's in the United States.
Gentlelady's time's expired.
Speaker, I'd move to extend time.
There's a motion to extend time. There's an objection to extend time. This is a record vote. The clerk will ring the bell. Show Ms. Garcia voting aye. Ms. Gonzalez of El Paso voting aye. Ms. Johnston of Harris voting aye. Mr. Spiller voting nay. Mr. Kane voting nay. Have all members voted? So Mr. Raymond voting aye. Have all members voted? There being 61 ayes and 82 nays, the motion to extend time is denied. The question occurs in the adoption of the amendment. There's a record vote. The clerk will ring the bell. Show Ms. Johnson of Harris voting aye. Mr. Spiller voting nay. Mr. Cook voting nay. Ms. Raymond voting aye. Mr. Dutton voting aye. Have all members voted? There being 59 ayes and 84 nays, the amendment fails to adopt. The following amendment, the clerk read the amendment.
Amendment by Morales-Shaw.
The chair recognizes Ms. Morales-Shaw to explain the amendment.
Members, this amendment is about how this bill would regard minors, which is a huge concern. So we don't know why minors come to this country, leave their homeland, and end up coming to our borders. But we do know is that our local resources and authorities are not trained, equipped, nor is there the funding to be able to deal with these immigrant children. It's fundamentally harmful to blanketly criminalize kids, and frankly, our jails don't have the capacity. This bill purports to be modeled after 8 United States Code section and how it defines aliens therein. However, when you're looking at the federal code, it has multiple steps later about dealing with minor immigrants, whereas this bill does not. For example, CBP and ORR, the Office of Refugee Resettlement, both of those are agencies and groups, professionals that are equipped, that have training, that have facilities, that have funding to be able to properly handle immigrant children, whether accompanied or unaccompanied. Starting with, for example, something as simple as determining their age. Because although you and I take that for granted, we have IDs, our kids go to school, there's all kind of documentation about how to understand their age. Immigrant children may not have those type of things. So at a very basic level, just having the expertise and the tools to be able to determine a minor's age is something that these entities are equipped to do. Local officials, again, have zero capacity to deal with this and things like special needs of minor children and special medical services. Again, CBP and ORR are equipped to do this. I speak for many Texans when I say I don't want to be a Texas that blanketly hangs a criminal tag on children's necks. And that's what SB4, written the way it is, would do. So this amendment makes an exception for children. Thank you. I move adoption.
The chair recognizes Mr. Spiller in opposition to the amendment.
Thank you, Mr. Speaker. I was handed the wrong amendment that I thought, what in the world does this have to do with this bill? But I now have the correct one. And let me say, it looks like what we're trying to do is add an exception if the actor is 17 years of age or younger at the time of the offense. Well, I think what my bill does is just provide, as it normally would under penal code provisions, and the age there is 17 or above, 17 or younger. I mean, obviously anyone under 17 would not normally be prosecuted absent some other exigent circumstances. And so I'm just saying, I think we need to not tinker with the framework of the other applicable laws dealing with age and the applicability of that to criminal offenses in our current penal code. This bill doesn't attempt to do that. It doesn't deal with that in any respect. And so I understand we're not trying to prosecute or go after children. That's not what the purpose of Senate Bill 4 is. But again, juveniles and others would be handled under our existing law. That is not changed in any respect. So I would respectfully oppose the amendment.
Ms. Gonzalez, for what purpose?
Will the author yield?
Sure.
The gentleman yield for questions. Gentleman yields.
Representative Springer, I've heard you say this a lot. It's not the intent of the bill, but if it's not the intent of the bill, shouldn't we just accept the amendment to ensure that we're not arresting children?
Okay, well, there's no, I get it, but there's no breakdown or different treatment for children under this bill. It is a criminal proceeding under illegal entry, is a criminal charge applicable the same way as it would be to any adult under the state of Texas. Doesn't deal with children, doesn't mention children, in a separate statute dealing with children, in a separate standard dealing with children. Children are, I mean, so it's inapplicable to a group here that is the subject of this amendment.
I hear what you're saying, but again, because it's just a blanket law, and thus young people could be impacted by this blanket law, and there could be unintended harms, making sure that we are not prosecuting children who really didn't have much sometimes decisions in where they are is really important. So I'm guessing if you say that's not the intent, and you're saying that's not possible, well, not even much, you're not saying it's not possible, you're saying that's not the intent. It's not the intent. Accepting her amendment just protects children, especially in a moment in time when we know TJJD is at capacity, when we know that our counties are at capacity with youth, our foster care system. So this is making sure we're not hurting young people is the more compassionate, the more common sense, I would say the better policy approach.
Right, and from what I've communicated and heard from with DPS, they're dealing with a number of issues with children, either unaccompanied minors, things of that nature, and they have to deal with that situation, how they're going to handle it, and certainly here, you know, I don't know of any instance really where we're prosecuting children. That's not created under my bill. It's not addressed in the bill because, in my view, it doesn't need to be addressed. That's general law anyway. I'm not saying that if a child, as that term is defined, not as it's defined here, but if a child has committed delinquent conduct or conduct in need of supervision on the provision of the Juvenile Justice Code as contained in the Texas Family Code, that's a different matter. But here, that's not pertaining to this bill. And not only that, but actually the age, as I understand it, would be 17 and above. What this amendment is talking about, if an actor is 17 years or younger. So I'm just saying it's really not relevant to the criminal charge of what we have. I understand what you're trying to protect. We've already talked about Children's Day. We certainly want to protect children, but my bill doesn't harm children.
Representative Spiller, I just have one last question. There's a lot of people who do have questions because the children aspect is really important to make sure that this is a very real thing that it could potentially negatively impact kids. But how do children have an intent to enter?
What was that, the last question?
How do children, so your bill talks about the intent to enter. How do children do that?
Well, I think, first of all, if children are involved, then law enforcement is going to have to make a decision. They've already testified in state affairs. Director McGraw has talked about, look, we don't generally separate children from parents, especially children from one parent. He made a distinction if there are two parents and so forth, but we don't want to separate children. But the children have not committed any criminal act. They've not committed any criminal offense.
I guess my question is, if you're saying this, why not just add the amendment?
Right. The short answer is I don't think it's necessary. Because, as I say, this bill does not address anything with children. Children are not included in this bill, and it's not really germane to the bill.
I will say this. I feel that the bill does apply to children, and that's where my concern, and I think other people's concern is. But that being said, I know people have other questions, so thank you,
Sure.
Mr. Representative Spiller, for answering my question.
Thank you.
Mr. Speaker?
Ms. Morales-Shaw, for what purpose?
Yes. Will the author yield for a
Yes.
quick question
Yes, I
and
will.
clarification? Thank you.
The author yields.
Rep. Spieler, I know you're saying that the bill isn't intended to affect minors, but they will be caught in this net because there is no exclusion for them. And if you mentioned before you're unwilling to make that because you think it's not necessary, would you be open to adding an affirmative defense so that if a child under the age of 17 gets caught in this net, which you said this bill is not intended to catch them, they will have an affirmative defense and they will be able to bypass the judicial system so that they are not criminalized inadvertently? As you say, this bill is designed not to criminalize them?
Okay, well, respectfully, no. But the reason I say no is because a person that's 17 or older is generally subject to the criminal laws of the state of Texas. Children under 17 are not generally, unless you fall within a strange category and are classified otherwise. So here, they would not be prosecuted. I understand that what happens here is affected by children, but the amendment talks about the application of the offense. The offense is not going to be applied to persons under 17 that I can foresee. It does apply to them if and to the extent that they are with an adult, whether it be their parent or whether it not be their parent. Just like the situation we had last week where you had adults and children and the adults were not the children's parents. So things happen, and I understand that, but children are not going to be prosecuted under this offense.
Okay, I think you're being very clear about this bill will not prosecute any immigrants under the age of 17.
Right.
Mr. Speaker,
Ms. Weiner, for what purpose?
will the gentleman yield for questions?
I will.
Gentleman yields.
Thank you. Representative Spiller, I'm looking at the Family Code, Section 5103, delinquent conduct. And what I'm reading is that conduct other than a traffic offense that violates a penal law of the state or of the United States, punishable by imprisonment or by confinement in jail. That's part of the definition.
That's
of
my understanding
conduct.
generally of the definition of delinquent conduct as opposed to conduct in need of supervision.
So you would agree that your legislation is creating new statutes in the penal code that are punishable by a term in jail and are not traffic offenses, correct?
Well, as you know, juvenile laws and are so forth, they are not really, juveniles generally are not technically charged, in my understanding, with a criminal offense. They're charged under juvenile justice provisions under having committed delinquent conduct or conduct in need of supervision, which could be classified as an offense were they adults.
So juveniles ages 10 to 17 absolutely could be prosecuted by local district attorneys under your law, correct?
But I don't know what you're asking me.
Well,
basically, if they were adults, but they're not, if they were adults, have they committed a criminal offense? And if they're, as a minor, as a child, coming across, presumably with their parents, or with someone that's not their parents, they're not the age of majority where they can consent to certain actions that are done. I can't imagine a situation where we're actually prosecuting.
So if you can't imagine it,
Gentleman's time has expired.
move to extend.
There's a standing objection to the extension of time. There will be a record vote. Clerk will ring the bell. Show Mr. Spiller voting nay. Mr. Cook voting nay. Have all members voted? Mr. Smith voting nay. Have all members voted? Being 82 nays, 60 ayes, the motion fails.